Well, I think we will begin this evening. Welcome to everyone joining our Society of Labour Lawyers webinar. This is the second webinar in our series on COVID-19 and justice. And this evening we will be focusing on the impact on our court system. We have three great speakers for you this evening. We have Andrea Coomber, who is the Director of Justice, the All-Party Law Reform and Human Rights Organisation, who's also an honorary master at the Bench of Middle Temple, and last year was appointed as a lay member on the committee, the Conduct Committee of the House of Lords. And we have got Stephen Cooke, who is a criminal barrister at 3 Temple Gardens, who was called in 2006 and does mainly defence work. And we have Hannah Gomersall, who's a family barrister from Coram Chambers, and was in 2018 shortlisted for the Family Law Young Barrister of the Year. So we will start this evening with and hear from Andrea. Andrea, are you there?
Right. I am. Can you hear me?
Yes.
Excellent. Well, it's a great honour and pleasure to join you in these really extraordinary times with my dog in the background. I was Zooming with David Lammy earlier this afternoon, who asked me to send you all his very, very best. And he was reminded that of all of the Labour things, parts of the Labour universe, the first one he joined was the Society of Labour Lawyers, and he looks forward to joining you sometime soon. David and I were talking about exactly what you and I are talking about tonight. Indeed, I've sent him my notes so he can pretend he was here. In the past 5 weeks, we have seen an unprecedented number of changes to the administration of justice in courts and tribunals across the country. As of today, more than half of the courts and tribunals are closed. We have 157 court buildings open for essential face-to-face hearings, a further 124 buildings open for HMCTS staff and the judiciary, just to conduct remote and video telephone hearings. We now, as of this week, have no jury trials in the whole of the country. Crown courts are dealing with some matters remotely, mainly sentencing hearings, urgent applications, pre-trial, preparatory hearings. And where most of our justice system, the criminal justice system, takes place in the magistrates' court, only urgent work is being covered. So there's been a real pulling back from a lot of crime. We've got fully remote hearings in the Supreme Court, in the Courts of Appeal, in the High Court. Some of that's been live streamed on YouTube. The civil courts have changed their listings to deal with the most urgent cases. Tribunals are suspended in-person hearings, with lots of them switching to telephone and videos. And while tax and employment have slowed down, every other tribunal has continued to work, bar war pensions. And in the highest volume tribunals, they're dealing with hundreds of cases every day by telephone. Incredibly, Ernest Ryder last week told me that Special Educational Needs Tribunal has actually been managing to start dealing with its backlog, which is pretty extraordinary. And the Chief Coroner said that all inquests between March and August are going to be adjourned. So there are serious concerns that I'll talk about perhaps to address and lessons to learn about this abrupt shift to remote hearings. But I think it's worth recognising that the judiciary, lawyers, litigants, anybody involved in the system, those administering the system, organising the system, have really done quite an incredible job in a very short space of time to adapt to kind of really new ways of working. At Justice, we've been involved for a long period of time in anticipating a move to more online justice. So much of this we were already kind of working on. But we've been engaged in COVID-19 work in the following 4 ways. Firstly, by briefing on the emergency legislation in England and Wales and also in Scotland. We've been working closely with HMCTS and with the judiciary here and in Scotland on ways of ensuring procedural fairness in remote hearings. And we've been conducting a survey of our members' experiences of remote hearings to inform our work, which I'll talk about a little. And the final thing that I'm not going to talk about in detail, but perhaps we can talk about in questions, is that we have last Thursday held a mock criminal trial by jury with a full jury council, a retired Crown Court judge, academic observers, to try out what virtue would look like for a jury trial, because we are concerned that the so much of the criminal system is just completely on hold. The user feedback might be worth quickly reflecting on. There's been, I think, a surprising amount of positive feedback for the way in which the system's adapted. Much of the positivity has come from those working in commercial areas of law, where conference calls with international clients are common, and perhaps remote working is more part of the culture. There have been many more concerns raised by people who work with underrepresented parties and vulnerable people, who've been more cautious, sometimes critical in their reviews. Although I have to say, very many people who I think 2 months ago would have said that a virtual hearing was an anathema to justice in any way, are now finding themselves much more comfortable with that possibility than I ever would have thought possible, that they can do a hearing in their slippers, for example, without having to leave their home, like we've all got used to. I've been in my Ugg boots constantly for the last 4 weeks. In light of our work with key stakeholders, we've got 5 areas of concern. Our first, obviously enough, is support for litigants in person and for vulnerable court users. We're concerned about digital exclusion, which is something Justice has been working on for the last 5 years. We're concerned about most vulnerable people, mental health patients, victims of domestic violence, people who lack capacity, prisoners. We're concerned that ensuring participation happens where hearings can take place. And we need to remain alert, and this has come up in some of the feedback we've had, to the risks of unseen pressures from others in the room or on social media or from unauthorised recording of proceedings. There's also been a lot written about, and we're concerned about, open justice. Current court listings don't enable court reporters, for example, to assess whether a hearing is something that should be attended. Hearings should be live streamed in our view. Supreme Court, Court of Appeal, you can catch all of them on YouTube, which is great, actually is a positive thing for open justice. And at the same time, I think we do have to be conscious of the need to be a bit more proportionate. So those principles of open justice might have to be limited in some circumstances simply to enable the administration of justice to proceed in these extraordinary times. But we need to then have recordings and transcripts uploaded and available as an alternative. A lot of the concerns have been around technology. The video platforms being used at the moment are variable, and it makes uniform guidance kind of difficult. People have been suffering through slow internet connections. I consider myself among them, just entirely outside the context of a court hearing, but we're suffering for the lack of sort of fast Wi-Fi. And that's been particularly the case in the examination of witnesses, that's become a problem for hearings. And there's also a need for ongoing technical support before, during the hearings. It's also raised an issue around formality, with a lot of people commenting that they feel like the informality that comes from Zoom or Kinley or one of the platforms that's being used doesn't convey the gravity of the justice system or the majesty of the law in the way that it's required. We did a report a number of years ago on court configuration, and that was one of the issues that raised, exactly how much gravitas do we want attached to certain court hearings. And I think there's a broader conversation there to be had around exactly how much formality is appropriate. But we've certainly lost some of that kind of ritual costume deference through these processes, so we need to have a think about that. And finally, there are issues around administration and communication. So people having fair warning about where hearings will take place in order to prepare, making the process more familiar for everybody, clarifying who's responsible for what in hearings. Some final comments. I mean, I think it's first of all worth remembering that the rollout was not planned. We've been very much caught off on the hoof. Everybody's having to kind of do the best of things. I was talking to one senior judge last week who told me that they're having to do hearings without a wig and gown because the building where his wig and gown are have actually been locked, and it turns out that the judiciary does not own the building. So he doesn't have his wig and gown. So it's a far from perfect context to move to a new system. And that's happened extremely quickly. I think there is a question for all of us about, to really boil down those essential elements of what an effective hearing really is about. I mean, is it about having wigs and gowns and a badge in the background? Ideally, perhaps, yes. But fundamentally, it's more about lay people being able to be heard and included and understood, and professional users being able to represent their clients' interests as best they can. And I'm sure we'll hear from Hannah and Stephen about other new skills they're having to develop to be able to deal with this. But it is, I think, important to just remember what are good hearings really about. And finally, I think we need to think about what happens when we pass this period of lockdown and the virus, and what this will do to the system. Will it mean we move to more paper-based decisions? Will it mean we have more procedural hearings via remote? I mean, to what extent is this whole experience challenging the idea that courts adjudication has to be in a physical court? So they're just my starting thoughts.
Great, thank you. We will be moving on to Stephen Cooke, criminal barrister. Before we do, I just wanted to make sure everyone knew that once our speakers have finished, there will be the opportunity for questions and contributions. So if you do have something that you want to say, please just put your hand up and I will be able to kind of switch on your video and give you access so you can ask your question yourself. If you'd rather not and you'd like me to ask your question or make your contribution, then just send me a message. But we will move on now to Stephen.
Hello, hi. I hope everybody can see and hear me all right. That was, as I've been introduced, I just wanted to really give a sort of at the coalface view as a practitioner who's going through these rather strange times and what it's like in practice. I was very interested to hear some of those things, and I'd be particularly interested to hear about how the virtual jury trials, that all pans out, and hear a bit more about that. If I just run through very quickly, sort of starting with the Court of Appeal and going downwards, how I've been finding things have been working. In the Court of Appeal, my own experience, I've had a hearing there under these strange circumstances, is that things there are working reasonably well with the remote hearings, because in the Court of Appeal, a lot of the work's in effect been done through written advocacy in advance, and the Court of Appeal aren't usually expecting a defendant to actually have much of a role in the hearing through speaking and saying things. And so in that context, actually, it works fairly well with the virtual hearing. In the Crown Court, obviously the huge change is, of course, that at the moment, jury trials are, as we've heard, suspended. That raises a big concern of principle about the delay in the Crown Courts. There was already a big problem with the length of time it was taking for jury trials to come in. I was finding in my own experience, and I know that this was mirrored across the board, and other people saw the same thing, that for defendants who are on bail, there was already a very long delay before cases were coming in, which of course has an effect not just on the person that's waiting for the trial, but on victims, witnesses, who often come to court all worried about their trial and then get told it's not happening for several months and they have to go away. And sometimes that can happen several times. And for defendants who are in custody, of course, up until this crisis, there was the security of knowing that there were custody time limits. I don't know whether that's a term that's probably familiar to everybody, perhaps given the audience of this, but just in case there's anybody who it's not, that's a safeguard that is in place in the criminal justice system to ensure that defendants don't wait too long in custody before their trial. And one of the things that's happened through this crisis is there's a protocol, and in practice, what's happening now is that lots of cases with defendants who are in custody, their trials are being adjourned beyond the period where they normally would be. Through these, the custody time limits are being extended, and this is becoming almost a matter of course because of this crisis that custody time limits are being extended. So one of the big concerns for me in terms of principle in the Crown Court is how are we going to deal with this huge backlog in terms of jury trials? And when this is over, is there going to be the resource, the funding, which in practice means more days for recorders, more courts being open, more opportunities to hear trials? We need to think that we can't go back to how things were before this started, because we already had a problem before this crisis happened. We already had a problem with delay in the system. And the fact that now there's been months of suspension is going to make that a lot worse. So that's the sort of big concern of principle that I have about what's going on, really, I think, in the Crown Court, that delay. In terms of practical issues, some of the virtual hearings are, in my experience, working well. Where there is a practical concern, it's to do with ability to speak to clients who are in custody. For some hearings, everything has been done and prepared in advance by solicitors. So for bail applications, for instance, there's a written bail application, and that you wouldn't normally have a client at court for Crown Court bail application anyway. And so that can still work virtually fairly well. But for other hearings, even where solicitors have already prepared and spoken with the clients, normal practice would barristers would see the clients at court, have those conferences, those conversations. And so there's a practical concern at the moment with not just how do counsel and the judges talk to each other, which is less problematic, but how can the counsel properly speak with the client, the lay client? And of course, at the moment, because we're in this crisis, a lot of solicitors' firms are under extraordinary pressures as well. And so just at the point when we're asking a lot more of them in terms of the fact that they can't go and see the clients physically, but still have to take extra instructions and more instructions because they don't have that safety net of knowing that the barrister will certainly be able to talk to the lay client at court. They have to do more, but with less, because a lot of solicitors' firms have people furloughed and they obviously face financial pressures because of this crisis as well. So the practical concern, particularly when a defendant's in custody, the defendant in custody may only have they often have to pay for access to the phone. They're concerned about paying for the phone, and there's all sorts of concerns about confidentiality and privilege. Because of course, to state the obvious, defendants in prison don't have access to mobile phones, certainly shouldn't do, and wouldn't be speaking to their solicitors on them. And so there's practical concerns about how defendants at this time speak to the solicitors, and how barristers at courts know that they're going to have the opportunity to speak to the lay clients. So that's the big practical concern. More so for some hearings than others, less of a concern for bail hearings, but much more of a concern for hearings where defendants are expected to be entering pleas, where any criminal counsel would want to be absolutely certain, especially before there was any possibility of a guilty plea. Ordinarily, counsel would go and check and double check with the client. They'd usually get an endorsement, they get something signed. All of those matters are a real concern if those kinds of hearings are going to go ahead. So that's a sort of practical concern about how those things are dealt with. In the Magistrates' Court, I should just say, because I'm no longer practicing in the Magistrates' Court very much, I've asked current pupils and up-and-coming new junior tenants what exactly is happening. So I should just recognise Mr. Kellum and Miss Egan for feeding me a bit of information about what's going on in the Magistrates' Courts. I understand that in Magistrates' Courts, the hearings are not all virtual. So people are going to Magistrates' Courts and still having physical hearings for remand hearings. I've spoken to them and asked them, how's that going? And is there social distancing and all those sorts of practices? I'm told there are some examples of very good practice with judges managing the situations and saying only one, akin to a youth court, only one lawyer in the court at the time, taping up chairs to ensure people don't sit too close to each other, having physical documents dealt with electronically to prevent transmission. all those matters. But good practice isn't universal. So there are still remand hearings happening, as I say, where people are going there physically, which is obviously a concern. And the good practice is not universal. I think on a sort of, if you forgive a very self-interested note, because it does have a wider implication for the bar as well, there's obviously a concern for the bar at the junior end. A lot of people come to the bar, and this is important in terms of equality and diversity and the sorts of people that have the opportunity to apply to the bar and start a practice. At the junior end, obviously, the government schemes to support self-employed people won't cover some of those people who come to the bar who will have just become a tenant and won't have had the 3 years of tax returns and the things that are necessary to provide. So there's a worry that lots of people who will have come to the bar, who will be choosing a legally aided profession and in doing that service, won't have that support. I don't know how I'm doing on my time. I hope that was a very useful, quick run through for points. And of course, I'm here to answer any questions about anything if I can later on.
Fantastic. Thank you very much, Stephen. We will next be hearing more about the family courts from Hannah.
Hi. I thought I'd give you first of all a quick overview of some of the concerns I have specific to the family courts, and I'll concentrate quite a lot on public children law, so care proceedings, because I think that's probably one of the most stark examples of how this works. I thought I'd just go through some of my main concerns, and then I'll go into detail about what I've experienced in a fact-finding case that I finished yesterday with Barbara Connolly, Queen's Counsel, who is also attending this seminar. So I thought I'd touch on some of the experiences there, which brought into reality actually what it means to have a remote hearing, not just for the lawyers, but in particular for the clients as well. Obviously, in care proceedings, we're talking about making very brutal, draconian decisions about children being removed, including newborn babies. And I just thought I'd say that I've heard anecdotally quite how traumatic that has become, because whereas you used to have an in-person hearing and a removal would, if it happened, you would still expect a new mum to be having 3 or 4 contacts a week. Now a removal is a removal. I mean, that then means very little contact between mum and baby because of the times that we're in. So the trauma to the attachment is even bigger, and the stakes are just so high, and yet we're having these hearings in a way that are really, we'd really struggle to say that it's Article 6 compliant, but it has to happen because these are child protection emergencies. But they're troubling practitioners. I know that they're troubling judges, because we've seen, I don't know if anybody read on the Transparency Project blog, there was a very interesting anonymous article from a circuit judge who was raising some real concerns about how to deal with those types of hearing. We are used to remote hearings. I think we're used to technology as professionals, and I think when people talk about online justice and remote hearings as a concept, they're often thinking about legal argument, about lawyers sitting in their nice offices with their technology running and making submissions to the judge on legal points. But of course there's clients in all of these, and in my area of law there's very vulnerable clients, and assuming that a client in those circumstances has access to a computer or even a smartphone, or even any phone with credit on it that's working, that enables them to participate even in a telephone hearing, is an assumption we shouldn't make. I had an EPO hearing at the very beginning of this crisis, where one of the mothers in the case couldn't call in because she had very young children with her there and then in the house. So very difficult for her to give instructions to her lawyers, let alone then hear and participate in a hearing. And the idea of there being any oral evidence was just completely impractical. So then you're in a situation where a judge is making these really troubling decisions without hearing oral evidence, without even really having had the full story from the client, because they've not been able to necessarily give instructions in the way they normally would do if they were at court, if social services had arranged that childcare in the normal way. I think there is a problem with the gravitas point. I don't think it's just about not wearing wigs and gowns. Obviously in the family courts we don't do that anyway. It's more about the draconian decisions being made in a way that must feel to a parent like they're not being heard, or they don't know that they're being heard. They're not being looked in the eye by that person making a decision about whether to remove their children or not. And so I think the gravitas, the formality is so important to recognising to participants in this justice system that they're actually that they are actually being heard and they're properly participating. The fact-finding hearing that I've just taken part in was part heard from an in-person hearing earlier in March. It was a case that was already way out of its ordinary time limits, and we felt that there was a real need to get on and finish the evidence. But there were so many, I think overall I'd say it was so much better than I expected. I was very sceptical about it being effective, but we made it effective and it worked. But it took an inordinate amount of going above and beyond what we would ordinarily do. It involved a client with learning disabilities having an intermediary, having breakout rooms on Zoom in order to try and make that work, having lots of breaks. It involved a prisoner being video linked in to the hearing, and at the beginning, when we were trying to work out how we'd make this all work, the telephone link company, I think, quoted in the region of £2,000 a day in order to bridge the link between the prison and a video service for us. In the end, the judge said that's ridiculous and just pointed a laptop at the normal video link screen as he sat in court in order to do that. But those are the sorts of problems that we're coming up against. My client couldn't operate a computer, didn't have a computer. We had to get the local authority to order him one, arrived at a solicitor's house who then loaded it up with the right software. I then operated that computer remotely through various software, almost acting like an IT person myself throughout the whole trial, taking him in and out of breakout rooms with his intermediary and back into the... So it was not easy, but it did happen and it did work. I don't think it would have been the right way to do it if it wasn't for the fact, for the needs of that particular case and the fact that we were halfway through oral evidence, and it would have been unconscionable really to have then delayed this for many, many months. And so I'll just conclude really by saying I am quite worried that at the end of this, this period of lockdown, we're going to find the family courts really struggling to keep afloat because all of these trials are being adjourned. There's children at the end of all of these trials, or in matrimonial finance cases, parties who need to move out of the house and are now in some places trapped together in a house they don't want to be in with each other. And they need resolution and they need decisions made, which are getting further and further away. So there's a really difficult balance to be had here between doing this fairly, but also getting on it and having decisions made. And I think it's going to have to be a constant conversation between the judiciary practitioners and clients about where the line is on all of that.
Thank you very much, Hannah. A really powerful contribution. For those who may not be as familiar with family law, Hannah mentioned an EPO, which is an emergency protection order, where you probably have gathered where a child can be removed. just to remind people, you can make a contribution or ask a question, and please just put your hand up and let me know that you would like to. We have our first question from Adrian Williamson, QC. Adrian, are you there?
I am, yeah.
Excellent.
Asked me to start my video. Yeah, the question I wanted to ask, and I think it's relevant to all three panelists, is that you've been describing how we're dealing with the current emergency. The current emergency at some point will come to an end, and at that point, there's going to be a big question, it seems to me, as to where we go from there, because the government is going to be looking to make, I mean, bearing in mind the public finances are in a much worse state than they were going into the financial crisis. This is going to be the worst slump in 100 years. We're going to have another round of austerity, and I can see two things coming down the track. One, government saying, well, we've had all these virtual hearings, we now don't need to have courtrooms. And two, jury trial is clearly far too expensive, far too difficult. Let's get rid of it, as the Scottish government threatened to do. So I was just wondering what you think are the longer term or medium term implications of the current situation.
Excellent. Andrea, can we start with you?
Yeah, I mean, I think Adrian's unquestionably right that we're going to be facing more austerity to pay back the bills, and that will mean, you know, legal aid will not be coming back in the way. Sorry, it's my dog whining because I haven't given him dinner. It will mean sort of legal aid not being returned in the ways that we might have been promised. It will mean that continued cutbacks in courts. Hugo, shut up. I think there is a serious issue around jury trial. The courts we can't continue to just adjourn depending on how long this goes on. I think suspension for the next kind of 3 months is probably unrealistic. So government will be looking to have have trials of serious criminal matters one way or another. So that would mean judge-only trials, trials with a reduced kind of World War II 7-juror jury, or what we're looking into is virtual, for which at the moment there seems to be, I have to say, very little appetite, simply because nobody can imagine quite how it would work. But I think there is a danger, as Adrian said, the Scottish government, I think, is already kind of minded to go down a judge-only route. And that's sort of where we're going to be headed if we don't find a way to get through this. Come on, Hugo, shut up. Sorry, very distracting.
Stephen, can I come to you next? Yes.
Now, obviously, people will have their own differing views about jury trial. Personally, I'd be a fierce advocate for keeping it. And I think it's a big concern for me. It's a very sensible concern, but it's a big concern, the idea that there might be thoughts for financial reasons to do away with jury trial. I think the idea that citizens randomly chosen deciding people's fate, bringing all their different life experience and all of those different arguments in favour of jury trial, I think need to be made. And I think it may well be that there's going to be that argument. And I do think, however, that we need to be open potentially to save jury trial. I think we need to be open to looking at other options like potentially virtual jury trials and those other options, precisely because, speaking for myself, I want it to remain and us to keep it. And I think that barring exceptional circumstances, which I certainly wouldn't want to see us going down the road of the normal frankly, during this crisis, I don't really want to see us starting judge-only trials, because I fear that if we start during this crisis judge-only trials, then it may be that the powers that be find that the conviction rate goes up, the costs go down, and it's rather hard to undo that. And so for my own view, I'd be very against that, because I fear that it might become a bit addictive and hard to give up once started. And I think it's a really important principle, the idea that we're tried by our peers and that it's not some part of the state. And I would be very against that. Although I know even amongst criminal barristers, there are differing views about that and differing views about jury trials. So I can only speak for myself, which would be that I think that juries approach cases with an open mind and bring lots of different life experience from lots of different things and a much broader pool than judges. And I would be, I note some other systems where judges are used in that way with sometimes alarmingly high conviction rates, which make one rather concerned. And I think that our system is very good at ensuring currently that people don't get wrongly convicted. And I hope that we hold on to those good things. So I'd certainly be defending jury trial if it comes under attack. And I would be wary about it being the thin end of the wedge if it comes in during this crisis. So that's I can only speak for myself. I think it's a very sensible concern. I am worried about it. And I think we need to hang on to it. In terms of what stays and what goes and other things, I think there are lots of hearings which could actually be done remotely. And I wouldn't want to take a view that all remote hearings are bad. I don't think that is a sensible view to take. I think that we have to make sure that defendants, particularly defendants in custody, have a confidential, practical, and sufficient chance to speak with their legal representatives. And that's the piece of the puzzle that's missing really at the moment to make it work across all the different hearings, in my view. That has to be solved, not a sort of rushed 5 minutes or something that's not, as I say, confidential, but a proper chance to speak to counsel. But in principle, there's lots of hearings that could continue remotely. But as I say, I think we need to hang on to jury trial. That's my view.
Thank you, Hannah. You raised already the concern about the backlog that will build up in the court's capacity to actually deal with that in family proceedings. How do you think that it will cope once things return to normal?
I mean, I think there was already a shortage of judges before this crisis happened, particularly in family courts. So I don't think it'll be easy. I don't think the government, I don't think the evidence will be there to advocate moving towards a more electronic-based system, because bluntly it takes so much longer to do a trial. I mean, my experience in the last 5 days is that it's so much slower doing a trial over Zoom. So I can see more case management perhaps going into remote style, or perhaps a few more case management things being done by telephone, or perhaps. But I think that I can't see trials staying remote after this finishes. I note that already the president of the family division has raised some real concerns about the idea of making welfare decisions for children and hearing from parents remotely. And I think that they're eyeing up a mountain of appeals that are going to come from conducting hearings with serious consequences in that way. So I don't think there'll be a temptation to move to too much remote stuff in family cases, because I think the judiciary will push back on that too much. I think you're muted, Catherine.
Just to make sure everyone remembers, you can make contributions and ask questions, so please do. I wanted to take the liberty as chair. We have said that some hearings actually work well as doing them remotely, and certainly I now, my practice is mainly civil and family, but when I was a criminal practitioner and sent to the Crown Court on £46.50 mentions, doing things and changing dates which could so easily have been done administratively. I was just interested in your views on actually some of the benefits that we might want to keep and things that might have now developed that will stand us in good stead to do some elements of our justice court system online. And certainly even with my civil practice, I've travelled the length and breadth of the country to attend hearings or on directions hearings where the directions are agreed, and it does feel like there's some things that this might actually take us into steps forward that weren't previously certainly they were taking some time to actually hit. I'm going to take it in order again, and actually if I just take a question, I've got a question from Barney O'Connor as well. So if the panelists are happy to take a few questions at a time. Barney, are you there?
Yeah, I'm here. Hello. So it's kind of the opposite of the last one. So part of it is some of the, I did IT before I'm launching at the moment, before I started this. Some of the changes to technology seem obvious to me. Like if you're building the court systems, you would introduce a lot of these things. So I just want to, obviously not in the courts, I'm not practicing, whether some of it might just be down to the lack of the correct technology, whether that be software and the hardware of the people using it, and then the education of that. And that's really it, that mainly that a lot of these changes do seem good, and especially like the jury from Stephen, if the system was made to, my hands are in the way, sorry, new camera. If the system was made with that in mind, purposely built, it seems doable to me, obviously, but I like to hear the opinions.
Okay. Thank you. I'm going to take a third question before going back to the panelists. Joe Vinson. Joe, are you there?
Hello. My question is about the magistrates court specifically. So I've been a magistrate for about 4 years now, and I know that the Magistrates Association have been calling for stronger sentencing powers for a long time, and I believe there's a provision within an act to give them powers to sentence for up to 12 months for a single offence rather than 6, and that the Justice Select Committee have been supporting that. I'm wondering whether, do you think the government are likely to change their minds now, given that maybe the Magistrates Court could do more work in this crisis and get some of that backlog down?
Thank you, Joe. So we've got sentencing powers in magistrates' courts, technology, and what the good benefits are that we might learn from. Can I start with Stephen? Because I think certainly the question about magistrates you might have a clear view on.
Okay, so technology, good benefits to learn from. Broadly, yes. I certainly recognise the picture, Catherine, that you just painted, that of travelling halfway across the country to have a 5-minute hearing with something that could have been easily solved to set a date. There was far too much of that, and those kinds of hearings roll on the technology. Nothing where everything's agreed should involve 2 people travelling across the country, where the 2 sides have agreed something in advance, 2 people travelling across the country. Thinking of the poor environment as well, it just seems daft. So yes, there certainly are those kinds of hearings. Picking up a bit on the question that we had about is this a technological problem, and can things be solved? I think the answer probably is yes, to some extent, because the biggest practical problem at the moment to more hearings working and functioning, to me, is this issue about proper involvement of the defendant and proper chance for counsel to speak to the defendant in a confidential and realistic way. And that's the biggest barrier. And that seems, to me, to be solvable with getting the appropriate technology in place. As was said, we've sort of stumbled into this. It wasn't something that had been planned and worked for. So I think I don't think it's as simple as technology good, technology bad. I think you've really got to look at the different hearings, and a lot of hearings can happen already. Another set of hearings can happen, provided that we work out a good technological solution for privileged, proper conversations to happen between counsel and clients. Jury trials, I don't know, and I'm sure it may well be that Andrea is the best person to speak to this. I personally have a completely open mind about anything that allows us to continue to argue for jury trials, where there might be a threat against jury trials. So I'm certainly approaching with an open mind the idea of something being virtual. I've got no idea whether it's practical or not. I can see all sorts of reasons why a jury trial would be a difficult thing technologically to have virtually, but I certainly don't want to rule anything out. If the argument might be we should lose jury trials altogether, I certainly don't want to rule out anything without knowledge and it being properly tried out. And I'm sure Andrea is probably better person to speak about that. Magistrates' sentencing powers. I'm not privy to what the government's intentions are, so I'm no better placed to guess what the government's intentions are. It's certainly something that's been there on the books, but not sort of come in to force for a long time. I don't have I don't have a principled objection to magistrates having more sentencing powers. I think that there's a lot of extremely conscientious and diligent magistrates who use their powers carefully. And I think obviously, so I'm not going to take I don't think I'm going to adopt a position one way or the other on that. I think it's an option that the government will consider, and I don't know whether it'll be used. I know some other barristers might take a different view, but as I say, there's I'm not going to take a position on
that. I'd be particularly interested to hear your thoughts on whether there are some elements of what's happening now that will translate well in the future into a family law practice, but also whether you think that technology can solve the problems that you have raised.
I think there's two different questions. One is can we do it, and then there's the second one, which is should we do it? And I feel like the family justice system in the past 3 weeks has gone from being quite excited that this was possible, and we were hearing these stories of High Court judges who were running complex trials through Zoom and it working, or Skype for Business and it working well, and then there was a bit of excitement that this can happen. And then it seems like in the last week we've had a lot more questioning of, hang on a second, even if this is possible, is it actually a good idea? Is it Article 6 compliant? Is this something that is not just good for the lawyers and the judge, but actually works for parents and the people who are subject to these court proceedings? I think that it's just worth bearing in mind, I think it was only Labour Party conference maybe 3 years ago where I remember we had an online courts forum panel thing, and I remember, and it was all about going online, the courts going online, and how wonderful it's all going to be. And I raised, to the surprise of some of the then front bench, that actually the family courts at that point didn't have Wi-Fi. I think it was only 2018 that we got Wi-Fi in the family courts for lawyers to use. And so I think the IT systems have taken a very long time to catch up, and they're not there for the judges. And I know that some judges who have been conducting these hearings have done so through their personal equipment, which they're not really supposed to do, but they want to help because their own judicial equipment isn't good enough to be running the software that's needed. But again, I come back to, it's all very well talking about the HMCTS structures. You're interacting, the justice system's interacting with these very vulnerable clients who themselves do not have that technology. And even if they did, the nature of the sorts of cases we're dealing with, people are there because of substance misuse. They're there because of mental health problems often, or domestic abuse. And to pick up on that as a human who's helping them remotely, the number of times that you've been able to have that frank conversation with your client about their alcohol use because you can smell it on their breath, that doesn't happen through a remote hearing. So I do think that there is I'm afraid it's not just that the technology doesn't work, it's just that it's not giving people the same chance and the same interaction and participation in the system, in my view.
Thank you, Hannah. Andrea, you're quite well placed to consider the questions, especially not only on benefits, but also on the future of technology. What are your thoughts?
I mean, I agree with Hannah that I'm not sure that there's very much beyond kind of case management stuff for the family courts, particularly public family cases, in the future for this. I mean, I just think people are too vulnerable. You need that human contact in that way. For other bits of the system, I think some bits of civil, there's probably more potential. It's not just a question of doing stuff online as well. It's also a question of doing things on papers. So for immigration and asylum appeals, we've managed to have the legal aid agency. I mean, it was a justice suggestion from a couple of years ago that actually, if you had better skeletons presented to the tribunal early on, the Home Office would just give up and there wouldn't be an appeal. And it was just simply a question of getting the preparation of those skeletons to be supported by the legal aid agency, which has now been done and ends up meaning no hearings, which is just a better outcome for everybody, and the lawyers are actually getting paid. So in not having to turn up. So it's also a question of having a look at those kind of front loading things to avoid hearings completely. I mean, the jury trial, I'll give you a brief kind of overview of it because it's not something we've talked about publicly at all. So this is off the back of a truck, although I think it's going to be in the Times on Thursday. We basically decided that we would put together a platform for jury trial virtually. And we did it last week with 3 days with the support of AVMI. They're a company who work with HMCTS on technology. They did it pro bono for us. And it provides a space where there's a jury room. All 12 jurors get to go into the jury room to discuss things. There's a room for the defendants and the defendants' counsel. There's a room for the judge and the judge's clerk. And then in the main screen, you have the defendant who, I mean, interestingly, the defendant is kind of in the middle of the screen, effectively, middle bottom of the screen, next to their lawyer and the prosecutor and the judge and judge's clerk, and then they're all 12 jurors. And we had it monitored and evaluated by Linda Mulcahy and Emma Rowden from Oxford, who have come back and said not only did they think it worked well, they thought for some things actually it was better than an in-person trial, in that the defendant was more present in their own trial than they would be if they were in a dock at the back of a courtroom, that their communication was easier. The prosecutor in the case felt like he had a much better sense of how he was going with the jury because he could see all of their faces kind of close up. There's not really, as we've learned all in the last couple of weeks, there's not really very much place to hide in a Zoom call. So there was that sort of intensity to the way it worked. The judge as well sort of gave really positive feedback. There were some things that we would change, and we are changing them, and we're doing another trial this Friday. But we're led just purely by intellectual curiosity to see whether it might be possible, because I think it's been too easy to say, not possible, 20 people in a courtroom is not feasible. And the alternatives at the moment, what are the alternatives? Alternatives are diplomat courts, or a reduced number of jurors, or not having any of these matters decided at all, and just leaving people who are beyond their custody time limit just in prison. So the alternative, if in the absence of other alternatives, I think it's worth at least having a go. And I wouldn't for a second propose that they should be used for complicated multi-handers or whatever, but for some kind of either way offences and other cases, it would allow there to be some kind of jury trial. So we will do the next trial on Friday. We will talk to the judiciary again. We'll talk to government. I talked to David about it today, but I think there's a possibility there, and I think we should at least be curious about whether it's possible without sort of writing it off as something that is impossible. Because it was surprisingly positive. The independent evaluation came back saying that on a number of metrics, actually, it was a more positive, a fairer trial than it would have been had it been in a physical courtroom, which is interesting. Right. And then just to Barney's question about saying like a lot of this is seems kind of obvious. I think probably for a non-lawyer, it would be obvious, but we're starting from a very low base, Barney. I mean, as Hannah said, until a couple of years ago, Wi-Fi was impossible to secure in most of the courtrooms across the country. So it has been an extremely quick kind of change, accelerated over the last 5 weeks, but even over the last few years. I mean, I would not have thought, when I started justice 7 years ago, I would not have thought this would ever be possible. In fact, 2 months ago, I wouldn't have thought this would have been possible. I just wouldn't have thought that people would be prepared to get on board with it in a way we've all been forced to get on board with it.
Thank you very much, Andrea. It's always good to get a scoop ahead of the times. I'm conscious of time, but I want to squeeze in one more question. We had a very interesting question from Claire Holland, and not just because she remarks that it's been an extremely helpful and interesting seminar, but if I could ask the panelists to answer the question, but then also to give any concluding remarks, that would be great. Claire's question is on expert assessments. She says, does Hannah or the other speakers have a view on assessments, for example, psychological parenting being conducted remotely, whether they can be robust enough and fair, ultimately Article 6 compliant to the children and carer, and if they are potentially more open to challenge at final hearing? But that definitely does, that applies both within the criminal courts and in the civil courts when you're looking at expert assessments. So Hannah, can I start with you on that?
Yeah, I mean, there's a number of family practitioners in the attending list, and I'm sure they've got their own views on it as well. My thought process is, at the moment, I've yet to have the case management hearing where we normally plan these sorts of assessments. I haven't got that far yet. I'm told that the courts are listing initial care applications now for July. So the first case management hearings in care hearings are now routinely being listed for July. I suppose in the hope that we're out of this by then. My immediate thought is that parenting assessments can't be conducted remotely. I cannot see how, when such an important part of a parenting assessment is observing interaction between parent and children, I can't see how that can realistically be done remotely. I think that would be incredibly flawed. It might be different if you were just writing an addendum to an already existing parenting assessment on some small point within it that needed some update or clarification, but I just don't think you can do a parenting assessment from scratch remotely. I think the same is probably true of special guardianship assessments, but there might be more scope to start the background work remotely on special guardianship assessments, and then maybe just have one face-to-face appointment a little later on, perhaps. Psychological and psychiatric assessments, I guess, I think they may be more amenable to being done remotely where that client has the ability to use video software to do it. I think you have to see the person's face. I can see, I'm being told by somebody that parenting assessments have gone ahead in the 3 hearings I've attended, even though some have tried to say they can do them in the gardens to retain social distancing. That doesn't surprise me that there's an approach which is to press on. But I think they will be very parenting assessments are vulnerable to challenge at the best of time at a final hearing. And I think if it's going to really depend on the amount of interaction that social worker has actually undertaken with the parents and children concerned. I think psychological and psychiatric assessments may be more amenable because you'd only have one appointment in those situations anyway. Catherine, you might have a view on this. I don't know what you think.
I think I agree with you. I'm surprised about parenting assessments going ahead, and I wonder whether there were specific reasons why it was a needs must kind of attitude. But certainly they're not ideal. And in some of the kind of the medical assessments that I deal with, I would have thought that for conditions that are fully resolved, that would be one thing, but I think that it would be very, very difficult to see how it would proceed in civil either. We have got a contribution from Claire as well, and has a psychological assessment of 3 children and family functioning there's one in today. So, and all of the interviews were done by Skype. So they are clearly happening. And I think that it will be really interesting to get insights from practitioners as to how they have worked, whether they were considered to be fair, and certainly see what happens if they're tested in higher courts. Stephen, can I come to you next on your views on, because obviously there are expert reports in criminal proceedings as well.
I think, in fairness to the questioner, actually, I think they were saying that no parenting assessments have gone ahead in their 3 hearings. I think.
Sorry, I had misread.
But Claire has mentioned that a psychological assessment of 3 children in today. So it sounds like certainly it has started, but it's just we haven't quite seen what's being received.
Yes, well, I think the question is probably a bit weighted more towards family, but in terms of psychological assessments, I've known, even before this, I've known pre-sentence reports be done without physically being there with prisoners. I've also known clients complain vociferously that they weren't properly listened to in those and not liking it. But that certainly has been something that has happened. I believe that I've also had, I'm trying to remember, certainly the normal practice was obviously for psychologists to see people in person. And I think I can't imagine that isn't better, but whether it's, whether that's quite as far down the track as the parenting assessment, as you say, it's usually one meeting in any event. Yes, I haven't had that situation yet during this period where so far, where there are those assessments, they've been put off rather than, so that hasn't sort of come to the crunch yet for me as to whether or not, but as I say, certainly important documents like pre-sentence reports have already been happening through virtual hearings, and I wouldn't rule out the possibility that the court take the view that a psychiatrist could do it via a remote hearing, but I can't imagine it would be as good, and it would be likely to lead to clients, I suspect, feeling that they weren't properly being heard. And I also think I'm sure we've had the experience of dealing with people who have mental health problems, and the combination of people who have mental health difficulties doesn't always go very well with remote technology. It can be harder to build rapport. It can also be much easier for them, if they want to ignore you or cause problems, to do so without you having the chance to sort of talk to them. And it's very easy for someone to hang up or talk at you and not listen over remote. So that I think there are particular problems with people who have mental health difficulties or other vulnerabilities in conjunction with remote technology, I think.
Andrea, if we can finish with you and what your views are on assessments in court that prepared for.
No, I mean, we haven't looked at assessments. We haven't looked at assessments specifically. I mean, I think there's obviously the issue of what the courts would think of them in terms of appeal. Beyond that, I'd be interested to know. I'd be interested to see some academic work on actually how it works. And because I think there sometimes is this, we have this sort of innate sense that something can't possibly work properly. And when there's academic research into actually how it does work, we're sometimes surprised. I mean, people are much better at judging truth, for example, on a telephone than they are on video. Like, we'd be all much better knowing who's telling the truth if we were on a telephone call now than if we were in a video hearing, which is not something that seems to make sense. And yet that is kind of if you look at the evidence base, that's where the evidence lies. So I think it's something that if we were to go down that route, which again I think is likely beyond this corona time, that would be something that would be worthy of being guided by an evidence base. The thing I'd just like to finally say is, I mean, Justice has done a lot of work on digital over the last few years. We did a report that came out 2 years ago on digital exclusion, which you would think would be relevant in this time, except that it's not. I mean, loads of it is completely unusable because it assumed that society would continue on as normal, you know, that there would be libraries for people to go to, that there would be advice centres, there'd be a CAB you could go to, and all of those sort of things. I mean, I think we do have to appreciate that the times we're in at the moment are really quite extraordinary. And so we need to be sure not to kind of judge everything that happens with technology too harshly in this particular context, because this is far from the normal context of the work. Yeah, so I think we just have to recognise, and my hat's off to Hannah and Stephen and to everybody who is experimenting, you know, with their clients' interests and lives and rights through this time, because it's a time where there just aren't any alternatives. You know, we just do the best we can, and hopefully that those sort of imperfect sort of alternatives will come up with the kind of best route through. But yes.
I will give Stephen and Hannah the opportunity for final comments, if you have any that you'd like to share.
No, I just think that in these strange times, just trying to do the best for the lay clients and protect their rights as best we can in these strange times. And I think that there are lots of hearings, all of those kinds of administrative hearings, where I think we can take this and learn from it and move forward. But we need to be very careful about all those circumstances where it can work against the interests of lay clients who are excluded or vulnerable. And we need to make sure that the technological changes don't work against the interests of people who are being excluded from it, whether they're in custody or have vulnerabilities in various ways. And I'd keep an open mind about whatever might be necessary to protect jury trial, which I am concerned about in the future. Thank you.
Hannah?
And I think I'll just say that I think a lot is going to depend on how long this goes on for, because you can delay trials, you can delay final decisions for children and families and divorces for 3 months maybe. I think if you get to a point of delaying significantly beyond that, we're just going to have to find a way through. We're either going to have to come in person, or we're going to have to just somehow manage remotely, even though it's very unideal. The positive I'll just conclude with is that I think there has been, certainly amongst family practitioners, there has been an incredible amount of discussion, support for each other, support for the judiciary, for our clients, a conversation that I don't think we've kind of had as a community for a while. So I think there's a lot of positives to come out of this. I think everybody has been quite supportive of each other in what are really challenging times, and we're kind of having a better understanding of each other's working practices, the judges' challenges, and how we can make our clients participate fairly in this. So, yeah.
Thank you. I think what has been clear is that there's been an incredible amount of ingenuity that has stemmed from the needs must that we have seen in these very strange times, and I think there's been some really interesting developments forced because people were just trying to make do. In a webinar like this, we can't quite get you a round of applause, but I just want to say a huge thanks to Andrea, Stephen and Hannah for their contributions and the questions and contributions that we've had from other participants. Next week, we are having a webinar on COVID-19 and immigration law. We will be hearing from speakers including Barrister Adrian Berry, solicitors Yawa Abbas and Ahmed Namazi. It's another area that has been hugely impacted by COVID-19. So another really interesting seminar that I hope that you will all be back for. But thank you all very much for joining us this evening, and see you next week.